Great. So it's a pleasure to see you all. Some of you already know me, some of you don't. My name's Michael. I'm an immigration lawyer. I specialise in asylum claims, and I've been specialising in asylum claims for many years. The people here that do know me will know me as an asylum lawyer. And for those of you that don't know me, people that have perhaps not been in this country very long, I hope by the end of today you'll have an understanding of things that are important to you, that are things that are going to happen in your lives over the next couple of years. So I'm going to give a basic outline, a basic talk in relation to an asylum claim. And I'm going to talk about it from the perspective of a person that's claiming asylum because of their sexuality. So for those of you that know nothing about this, I'm going to direct a lot of what I say to you. But for people that have a bit more experience, I'm also going to talk about some things that might be important to you that you're unsure about. So we'll cover the process of an asylum claim first, and then we'll cover the legal requirements that you have to satisfy in order to be granted asylum and allowed to stay in the UK. And then we'll talk about a few other bits and pieces afterwards that are important. For example, what you need to do if you want to bring your children to the UK after you've been granted refugee status. Okay. Now, when you claim asylum, you are asking the government of the United Kingdom to allow you to remain in this country because you are at risk of going back to your home country. And so to start that claim off, you need to present yourself to the UK government. And there are a number of ways that you can do that. The most common way is to contact the UK government, the Home Office, and to make an appointment to go to the asylum screening unit to claim asylum. Now, there is a phone number on the UK government website that you would have to call, and you would call them and say that you want to claim asylum. Once you give a couple of your basic details, such as your name, your date of birth, your telephone number, they usually then call you back and book an appointment for you. And at that appointment, you will give some more basic details about your asylum claim. This is what we used to call a screening interview. They now call it a first contact or an initial contact interview. And they'll ask you questions about your journey to the UK, about your work history, about your family members, and they will also ask you some basic questions about your claim. Not detailed questions, just basic. For example, why are you claiming asylum? Who do you fear? But not detailed questioning. Okay? After that happens, they will then take you to the next stage of your case, which is known as your main interview, your substantive interview. Okay? And there is usually quite a long gap between interview 1, the screening interview, and interview 2, the substantive interview. And often a person during these two interviews will hire a lawyer or will instruct a lawyer to help them prepare their case. Okay? Some people have already instructed a lawyer before they even go to their first interview, but you'll still have a lot of time between interview 1 and interview 2 to get a lawyer to help you prepare your case. Often, during interview 1 and interview 2, that period in between, the UK government will give you a form to complete. It's known as a preliminary information questionnaire, which is kind of like a witness statement. But if you have a lawyer that's representing you, they'll help you prepare your witness statement in which you say your whole story, all of your reasons why you're claiming. Okay? And you would then submit your statement with that questionnaire and with any supporting evidence. When you go to your interview, your main interview, it's going to be a long interview. It lasts several hours. Often, people will be asked more than 100 questions, sometimes 200, sometimes even more than that. And it will go through all of the parts of your case that need to be decided upon. If you do have a lawyer that has prepared a statement, almost all the issues that are going to be covered in your interview will have been covered by the lawyer in the statement. Okay? And then, after your interview, the UK government will make a decision on your claim. And they will either grant you asylum, which is refugee status with 5 years limited leave to remain, or they will refuse you asylum. If they refuse you asylum, you will be given the right to appeal the refusal to an immigration judge, who will then decide your case. Okay? And obviously there is a process for appealing, and if you have a lawyer, they will normally advise you on the various steps. There are certain deadlines that you have to meet, but that's your case from start to finish. If you do have an appeal and you lose your appeal, sometimes people do, there is the possibility that you can make a fresh asylum claim after you've lost your appeal. And that could be because there has been a change of circumstances, or it could be because you have evidence that you didn't have when you made your claim or did your appeal. And again, a lawyer would advise you on what you need to put forward in any fresh asylum claim that you make. Okay? That's the process from start to finish. There are quite a few other bits and pieces at play during that, but that's the basic process that you would face. A lot of people, and I know this from my experience of representing hundreds of asylum seekers, are very apprehensive, very worried about their main interview. They're worried that they're going to get things wrong, that they're going to be caught out, they're going to be hit with questions that they didn't expect. Some people are talking about things that are very traumatising for them, that they've never spoken to anybody about before. And so the interview is something that people are very scared of, that they need time to prepare themselves for. Normally, if you are represented during your claim and you're giving a witness statement, the lawyer that's taking your statement will help prepare you for your interview. And so by the time you actually get to your interview stage, you will feel a lot more confident than you felt at the start of your case, when there is this big scary interview that you're going to have in a few months' time. And so by the time you get to that interview, if you're well prepared and you've given a statement, you will feel a lot more comfortable about it. And in my experience, people usually are a lot more comfortable. The hardest part is probably making that first phone call to the Home Office, saying, I want to claim asylum. Once you've done that, everything else is just a stage after a stage after a stage until you get to your interview. Okay? In terms of the legal requirements that you need to meet, okay, now, asylum law from a lawyer's perspective can be quite complicated. So I'm going to break this down for you in some very simple terms, okay, so that you understand. You are required to show that you are genuinely at risk of persecution in the country that you're from because of a particular reason, and for somebody within your category, which is that you are lesbian, gay, bisexual, transgender, etc., that would be a membership of a particular social group. That's the legal term, okay? Now, you have to show that your claim is genuine and that it's well-founded. What that means is that you are a credible asylum seeker. Now, when the government assesses a person's credibility, they're assessing things in the round. It's known as a holistic assessment. And so they look at everything, including a person's immigration history, the other things that they've done in their lives leading up until their claim, okay? But despite everything being looked at, the most important thing for you to establish is that you are genuinely gay, okay? And a lot of people will not know or understand how it is that they can establish that they're genuinely gay. It might seem like a ridiculous question to you, okay? Of course I'm genuinely gay. Of course I'm genuinely a lesbian. It's ridiculous for you to think otherwise, okay? But we have to play on the terms of the UK government. And so there are certain things that get assessed and there are certain things that should not be assessed, okay? A person's sexual practice should never form part of the assessment. It's a breach of a person's human rights for that to be part of the assessment. A person's demeanour or certain stereotypical notions of what it means to be gay or lesbian or bisexual should not come into the assessment, okay? Similarly, medical tests or things like that shouldn't come into the assessment. The thing that should be assessed is a narrative of a person's identity during the course of their life, starting from the very beginning all the way up until they've come to the UK and claimed asylum. And when I say the very beginning, I mean that first time that you began to realise that you were different from other people, okay? And then we look at a person's journey, their emotional journey, leading up to when they realise they're gay, when they realised that they were different to other people, when they learned to accept it, whether they have accepted it. Some people haven't. Some people struggle to reconcile their sexuality with their religion, with their other cultural beliefs, okay? But these are important things for us to have an understanding of, because it's establishing these things that demonstrate the genuineness of an asylum claim, okay? And so when we provide a witness statement, a narrative of a claim, we are going into lots of detail in relation to this story, in relation to this person's emotional journey, okay? Now, when I take witness statements from my clients for their claims, I will spend 10, 15, 20 hours with them going through their story. The actual statement itself will be as long as a book by the time we're done, because that's the level of detail that we're looking to go into, so that we can show a person's genuine emotional journey in relation to their sexual identity, okay? And there will be other things that perhaps objectively don't look good in terms of somebody's credibility. For example, if they entered the UK illegally, if they became an overstayer, if they used somebody else's document. Sometimes people have to do these things to get to a safe country, okay? And these things can be taken into account when assessing credibility, but they are not fatal to a person's credibility. The most important thing is the story, the narrative. And if we have a strong narrative, then that will withstand any problems in terms of a person's actions or immigration history leading up until their asylum claim. Now, the UK government has rules on evidence, okay? The rule is that if you do have evidence to support your claim, you should provide it. But if you haven't, that's okay as well, because often people leave their country in a rush. They don't gather up all their things. They don't take all of their evidence. They're too busy trying to get out of the country as quickly as possible in order to be safe, okay? So if you don't have evidence, that's okay, but you should explain why you haven't got evidence, okay? And again, if we have a strong enough story, a detailed enough statement, then we might not necessarily need evidence to support our claims. But everybody's case is different. We might have evidence. For example, if somebody has been threatened by family or friends on social media because they've been outed or something like that, we can reasonably get that evidence. Sometimes people can't. Sometimes people delete their internet profiles and things like that because of fear, okay? But we would need to cover those things as well. Now, separate to credibility, we have other legal requirements as well. The main one, after credibility, is whether the country that you're from persecutes people like you, okay? Now, I heard a lot of people giving their names and nationalities, and I would probably say that Uganda is the most represented country here. Would everybody agree with that? Yeah. Well, we all know what happens to gay people in Uganda, okay? And the UK government knows what happens to gay people in Uganda. And so, if you are a credible asylum seeker from Uganda, the UK government will grant you asylum, okay? I heard people reference countries like Nigeria and Kenya and Tanzania and Ghana. These are also countries that persecute gay people, okay? And so if you are claiming asylum from one of those countries, the UK government is also likely to accept that you are genuinely at risk of persecution. Now, the other legal requirements include things like being able to get protection from the police in your country or being able to live safely in a different part of your country, okay? Now, the majority of African countries do not have a police that are going to protect them from homophobic persecution, okay? The UK government is aware that there are some parts of Lagos where there are LGBT groups, okay? But generally speaking, Nigeria is an unsafe country. So even though there is some of that support in Nigeria, a Nigerian asylum claim will still succeed, okay? It will not be defeated by there being groups operational in Nigeria, okay? So these are the main requirements. Put simply and bluntly, you have to show that you're credible, okay? And the way that you show you're credible is by providing a very detailed narrative of your case, talking about your emotional and personal journey in relation to your sexuality. Now, I know that that will be hard for a lot of you because you've never spoken to anybody about it in your lives before you came to this group, okay? And you've spent your whole life repressing it, not talking to anybody about it. We know it's going to be hard for you to talk about it. Similarly, a lot of you are from places where there are not words to describe your feelings. The language doesn't cover it, okay? But this is what we're here to do. As lawyers, we're not just people that advise you on law. We're people that translate your feelings into words that represent a proper narrative, okay? So this is what we do, and this is what we're here to help you do. So this covers the law. This covers an asylum claim, okay? Now, in terms of fresh asylum claims, I want to say a few things on this. Because some of you, and I don't know what stages you're at, if you're at the point where you've had an appeal that you've lost, but if you're claiming or making a fresh asylum claim, the law is a little bit different. Yes, you have to do all the same things that I've just outlined for an asylum claim, but also you have to put your case forward in a way which means that if the Home Office refuse you, you can still go to a judge again and get them to decide your case. And the way that you do that is by showing that your case is either materially different from the case that was presented before. And when I say materially different, I don't mean a new story, because your story is going to be the same, okay? It's about your evidence. It's about how you supported your case. It has to be materially different to what was put forward first. And then you have to show that there is a realistic chance of succeeding in an appeal, okay? And so a lot of people may have lost their appeals because the appeal wasn't properly prepared, because there wasn't a statement that went into lots of detail, because they didn't explore these areas of difference and stigma and shame in their original statement, which is something that should be covered, okay? If that's happened, if you didn't have a properly prepared case in the first instance, then get a properly prepared case in the second instance, okay? And you can show with that that your case is materially different to the one that was put forward the first time, okay? And I've had lots of instances in the past where somebody, as a failed asylum seeker, and when I say failed, I mean they've lost their appeal, has come to me and has shown me the evidence that they submitted in their appeal, either with their previous representatives or on their own because they didn't have representatives, okay? And if that evidence is non-existent or very thin, then I prepare the case properly. I do proper statements, proper evidence, proper narratives. And when I do that, I can usually show that the case is strong enough to get over this legal test. And if the Home Office still refuse it, we get to go to a judge, okay? So these are the key legal differences with a fresh asylum claim. Now, a lot of you, and I know this from experience as well, will have been pressured or forced or coerced into a marriage or something like that in order to demonstrate that you are straight in a country that doesn't accept you, okay? And so because of that, a lot of you may have children. You may have children in your country that have been rejected by the other parent, okay, and are living with friends, grandparents, whoever. If you're granted asylum, you can bring your children to the UK as your dependents. It's called a family reunion application. And you'd have to provide evidence, including that those children were part of your household before you left your country, and you'll have to provide some other things as well. But usually, if you can provide all of this evidence, the UK government will allow your children to come to the UK to live with you as your dependents on your asylum claim. And then they will get the same status as you in this country. And when you get to the end of your 5 years leave as a refugee and you're applying for permanent residency in the UK, your children will be able to apply with you at the same time. Now, when you're granted asylum, there are certain rules on what you can and can't do, okay? You can't keep the same passport. So if you have a Ugandan passport or a Nigerian passport or a Ghanaian passport, you cannot use that anymore, okay? If you want to travel to another country, you have to get a travel document from the UK government. If you applied for a passport from your own country after you've granted asylum, or you use the passport that you already have, that could result in you losing your refugee status, and that would take you all the way back to square one. Similarly, you cannot travel to your own country whilst you have refugee status for the same reasons, and it could also result in you going back to square one. Now, the rule on travelling to your own country is not automatic. So there are very limited circumstances in which the UK government will accept you travelling to your own country. For example, if there is an emergency such as a bereavement or something like that. But in those circumstances, you have to provide lots of evidence. I have a lot of clients that come to me and say, my father is terminally ill in my country. Can I go and see them even though they've got refugee status? Okay. My advice to them is let's write to the Home Office first and let them know the situation and let's see what they think. If you don't do that, if you don't write to the Home Office, but you've got all of this evidence, you can still argue that it was a one-off emergency. And when you apply for your indefinite leave, the Home Office might accept that. But there is a risk, okay? And so it's a question of judgment for you. And the way that we mitigate that risk is by writing to the UK government first and letting them know the position and seeing what they think about it. Okay? Now, I think I've covered broadly all of the areas, the process, the legal requirements, fresh asylum claims, family reunions, refugee status. One final thing to say, and it relates to what happens at the very end of the process, which is British citizenship. Now, if you're looking to get British citizenship and a British passport, that's possible. Most people are allowed to apply for the British passport after they've held indefinitely for 1 year, okay? But that's not always the case, because some of you might have overstayed your visa before you claimed asylum, or you may have entered the UK illegally, okay? If you have overstayed your visa or entered the UK illegally, then the amount of time that you have to wait for British citizenship is longer, okay? The rule on this, it's known as the good character requirement, is that you cannot have been an overstayer in the 10 years before you apply for British citizenship. So let's say you come to the UK in 2015 as a visitor, you overstay your visa, you claim asylum in 2016, you're granted refugee status in 2017, okay? If you then hold your refugee status for 5 years until 2022, get your indefinite leave to remain, you're not going to be able to apply for British citizenship in 2023. You're going to have to wait a few more years because of the period that you were an overstayer before you were granted asylum. So if you did overstay before you granted asylum and you're at the end stage of your case, having been granted indefinite leave, speak to a lawyer because they can do the calculation on when you qualify for British citizenship. Okay? So I think that covers everything. Now, I'm happy to answer any questions from anybody in relation to any of the areas that we've just covered or anything else that you'd like to have an answer on. So I'll hand it over to you. Hi.
I would like to ask about bringing children. You spoke about bringing children in case they will accept my asylum. There is any limit of age of children, or
there is.
Any child can come?
The child has to be under the age of 18.
Have to?
The child has to be under the age of 18.
All right.
Once a person reaches the age of 18, they are no longer considered a child. However, if somebody applies before they turn 18, then they are allowed to be considered a child all the way through until British passport, okay? So let's say you get granted asylum, you've got a 17-year-old child, you do a family reunion application for them, they come to the UK as your dependent, and then 5 years later you're applying for indefinite leave, and that child is 22 years old at that point, okay? They are still allowed to apply as your child because they did the first application before they turned 18, okay? Hi.
Hello, Dorothy. It's a follow-up question from her. It was about age. Now, my question is about the children who are not biologically yours, but they've been living under your.
That's a much more complicated situation. So this is an area that I kind of encounter quite a bit. Part of the process for applying for a child is proving that that child is yours. That's the first thing. And so even for children that are biological children, I tend to advise clients when doing a family reunion that they should get a DNA test done, okay? It's not mandatory, but in order to avoid delays and complications and having to go to appeals, it's just a lot more straightforward to get that DNA test done, okay? If the child is not biologically yours, then technically they are not your child for the purposes of the immigration rules. However, there may be other grounds for them to apply to enter the UK, and there are various human rights claims that can be made. And so if you have a situation where you have a child that you consider to be your child because you've brought them up, you've raised them, but they are not your biological child, it's probably best to speak to a lawyer who can look at all of the circumstances and work out the best solution for you. Yeah.
My name is Tim. I just want to ask, you're talking about a visa overstay. So from the point of making one's intention known by calling the Home Office, let's say from that point you have maybe like 2 weeks to the expiration of your visa and you call to make your intention known. Do we consider that a visa overstay, knowing that it's going to take a while before you get your asylum?
So I'm going to explain perhaps one of the more technical areas of immigration law, something that as lawyers we deal with on a day-to-day basis, and it's about maintaining a continuity of leave, okay? Now, if you have a visa and you make an application for a new visa before your visa expires, then your application for the new visa automatically extends your previous leave so that you do not become an overstayer. Okay?
Is it possible to make a request for a new one in country?
So this is the issue that I'm... So let's say, for example, you have a visit visa and your visit visa expires in 1 week, okay? If you make an application for something else before your visa expires, and when I say make an application, I mean a valid application, then it extends your existing leave and you do not become an overstayer. This is a bit more complicated with asylum claims, okay? Because your asylum claim is not officially considered as being made until you have been to your screening interview, okay? It's not when you make the phone call, it's when you attend your screening interview. So if you make that phone call 2 weeks before your visa expires, then you have to tell them on the phone that your visa is expiring in 2 weeks and that they need to arrange your screening interview before your visa expires. Okay? That's the only way you stop yourself from becoming an overstayer.
And you're sure they're going to grant that?
Well, if you've got a lawyer that can argue it properly for you, then yes.
Okay, so another question. Do you think the situation in Ukraine at the moment is going to affect the process of asylum or refugee documentation, given that the UK is going to see a number of influx of refugees from the UK, whether we like it or not? Do you think it's going to affect, the status of maybe LGBTQ people's
That's a difficult thing to predict precisely because there have been quite a lot of things that have happened over the last couple of years that have affected the process of asylum claims. For example, when COVID-19 started in 2020, there was a short period of time where there were no interviews taking place. And up until 2020, the only place that you could have your screening interview was in Croydon at Luna House. And then when COVID happened and the social distancing meant that Croydon couldn't be open all the time, they started having screening interviews at different venues so that they could continue to process asylum claims. Okay, so there is often changes that are being made to process based on various kind of social and political issues of the time. It may be that if there is a very large influx of Ukrainian refugees, that might alter the asylum process. But as things currently stand, the process is fixed. It's something that we need to keep up to date on, and it's something that if you have a lawyer, you can expect them to advise you on as the process changes. Does that make sense?
A lot.
Yeah. Okay. We have two people. Who wants to go first? Okay, go on.
Go first. I just wanted to know what they mean by fast track.
So fast track no longer exists. Detained fast track was something which was part of the asylum process a number of years ago, and it was for people whose claims the UK government considered could be decided quickly. And often, when a person went to their screening interview in Croydon, Luna House, if the UK government decided that their case was suitable for fast track because it could be decided quickly, they would then detain them at their screening interview and put their case through a fast track process. And fast track would often mean an interview within 2 or 3 days, a decision a couple of days after that, okay? But there was a lot of legal action that took place in 2014 and 2015, which eventually resulted in the fast track being abandoned. Now, I represented quite a lot of clients from various organisations, including this, at the time that fast track existed. And for people that had asylum claims that were non-fast track, there would often be very long waits for interviews and things like that, which meant you had to wait a year, 18 months before you were granted refugee status. And at the time, I noticed that some people actually wanted to go into the fast track because it meant they could be granted asylum quicker, okay? But it did mean detention for people. And so now the process is not fast track. There are still some instances in which asylum seekers are detained, but often it's because they've been detained for other reasons. For example, they've been serving a criminal sentence in prison and they've claimed asylum because they're facing deportation. Okay, but the detained fast track in the way that it was kind of in existence in the mid-2010s is no longer in existence. Okay. Hi.
Hello, I'm Martin from Cameroon.
Hi, Martin.
Just want to ask, can I have more detailed information about adoption when it comes to gay couple? Can the gay couple decide to adopt a child back home?
So this is a very complicated area, okay? And essentially the UK government has a list of countries whose adoptions are accepted as being legal adoptions for the purposes of immigration and nationality law. Off the top of my head, I can't tell you which countries are on that list and which aren't. I do know for a fact that Nigeria is on the list of countries whose adoptions are not accepted, okay? But just so that you know, if there is a legal adoption that has taken place in a way that's accepted by the UK government, then normally that will mean that that child has the same rights as a child that is the biological child of the parent in question. And so family reunion rules, British citizenship applications, all of that follows, okay? There are a few other areas in terms of applying for kind of temporary leave to remain in order for an overseas adoption to be lawfully recognised in the UK, but that kind of takes us into a much more complicated area. Okay.
The last question, please. What advice would you give someone who's just called the Home Office to claim asylum and the person has been waiting for, I would say, 10 months now, which I know someone, and never have any answer, nothing?
To be persistent. I've seen this for people that I've represented, where we've called for arranging the screening interview, and then the Home Office say, we'll get back to you in the next 2 weeks, but it's taking a long time because there are delays, etc. Then they don't get back to you. You have to just keep being persistent. If it gets to a point where the delay is unreasonable, and in my opinion, in that situation, a delay will be unreasonable if it's more than a month between phone call and screening interview, then you can start making formal complaints and doing things a bit more aggressive. You can contact your MP in the area that you live. You can make a formal complaint. You can even make a threat of legal action against the UK government for their unreasonable delay.
What if you have a sibling or someone that you are taking care of, but because of that you left and you're now home?
So the strict family reunion rules only apply to partners and children. If there is another family situation, such as a sibling that you're taking care of or some other arrangement like that, then that takes you, like I mentioned earlier on, into a more complex human rights territory. And it's something that you would want to talk in detail to a lawyer about, to look at the circumstances to see what sort of human rights application could be made.
Hi.
Hi.
I want to ask about the social media. To what extent does it contribute to someone's case?
That's a very fair question, okay. The UK government's position on this is that social media evidence of LGBT activism in the UK. Is that what you mean when you're talking about social media? That is not proof of sexuality. It's proof that you are involved in social media and involved in activism. You can argue that that's part of your wider narrative, but do not let that detract from the core part of your case, which is your sexual identity. It is more important that you provide a detailed narrative of your life and your experience than providing hundreds of pages of screenshots of you going to rallies, okay? The importance of that is far below the importance of a credible narrative of your sexual identity.
When you have a court date, like when you appeal and you're waiting for a court date, and all of a sudden your lawyer tells you that that the date is this date, what the court has said, but your barrister is not allowing that date, what would you do? Do you go and stand for yourself if you think you can, or you have to wait for that?
So just to clarify, you've been given a date by the courts,
Yeah.
and your lawyer has told you that your barrister is not available on that date.
That date, yeah.
Okay. Now, as a lawyer, what I do is when I get the date, I then ask the barristers' chambers what barristers are available on that date. Okay? And I then instruct a barrister based on their availability. If I have a barrister that I want to represent a client in their appeal, then I will instruct them early. And when we are in correspondence with the court, before the court's given us the date, I will tell the court what dates the barrister is not available so that they can list the hearing on a date that the barrister is available. Therefore, if you've been given a date that your barrister is not available, then your lawyer should be looking at what other barristers are available, or if it was specifically that barrister that should have been representing you, then you need to find out, one, why they didn't tell the court about the barrister's availability, and if necessary, advise the court that they need to change the date to a date that the barrister is available. I can tell you the court's going to be very reluctant to do that because the court, which is full of judges, most of whom are barristers themselves, will know that if you do not have your barrister available on that date, then you need to instruct another barrister, okay? Unless that barrister has already been to court for you once. If that barrister's already been to court for you once, then you've probably got a better chance of the court agreeing to move the date to the date that that barrister's available.
I just wanted to ask in regards to the court hearing,
Mm-hmm.
what could be a credible evidence in regards to your sexuality? Because you said
It's what I told you at the very beginning. It's your story. It's all about your story, okay? You have to have a strong, detailed narrative. By the time you get to court, okay, you will have been well practiced in talking about your case, about your experiences. You will feel a lot more confident about it. And there is a possibility in court that you'll be cross-examined, okay? Do you know what a cross-examination is?
No.
It's when the representative of the other side asks you questions to try and trip you up, okay? To try and get you to fall on your own answers, to get you to say inconsistent things, okay? Now your lawyer and your barrister will prepare you for that cross-examination, okay? They will make sure that what you're saying is consistent. If there are inconsistencies, they will highlight those inconsistencies and work out why there are inconsistencies and how you address it, okay? But in terms of proving your credibility to the Home Office, to the court, to whoever, it's all about your narrative. That's the most important thing. Everything else flows from that. If you've got evidence to support your case and you are reasonably able to get that evidence, then you should provide it. But not everybody can. But everybody does have a story, and that's their most important weapon in their appeal. If your narrative is strong enough, if it's credible enough, then it will withstand those things. I've represented people that have come to the UK as visitors, have overstayed, have hidden for 10 years, 15 years, have had relationships, heterosexual relationships in this country because they've been forced to by their community, that sort of thing. Then they've had the kind of advice and got involved in organisations like this, and they've had the confidence to claim asylum, okay? And then I prepare a very detailed statement and story and explain absolutely everything, okay? And despite all of those things that have happened in the past, which could be hugely damaging to their credibility, we have still been able to succeed with their asylum claim because their story, their explanation is strong enough to withstand it, okay? There is no single thing which completely kills a person's credibility, okay? Everything is considered together, but it's the story that's the most important thing. Yeah. Hi.
My question is for those who got permission to work, how does it affect the weekly paid or nurse accommodation?
So you can only get NAS accommodation or NAS support if you have no other income, okay? There are some limited situations in which a person can be means tested for NAS support, but if you have permission to work and you're working, okay, then you won't qualify for NAS support. If you have permission to work but you're not working and you have no means of support, then you may be able to get NAS support, okay? But it's the same as any other kind of benefit situation. It's means tested. They're looking at your situation, your circumstances. Does that make sense? Hi.
Just wanted to ask, like, if one is going for a court hearing, what do they expect in the court hearing?
So I do a lot of advocacy in the tribunal. And when I say advocacy, I mean I do the job of a barrister. I go there and I actually argue the case in court, okay? And what I do, and it's what barristers do as well, is I have a conference with my client before the hearing where I explain to them what's going to happen in court from start to finish, okay? And I'll tell you now what that is. So when you go into court, there's going to be a judge, okay? And they're the ones that decide your case. There is going to be you're the appellant. There is often going to be a representative for the Home Office, but not always. They don't always turn up. And there is going to be a representative for you if you have instructed a representative. And that could either be your lawyer or your barrister, whoever it is that you've instructed. There will also be your witnesses, but they're not going to be allowed in the courtroom unless they're giving evidence. And there could be people that are observing the hearing as well. But if you do not want them in the room, you need to tell the judge, because you're going to be talking about very private things, very sensitive things, and you can ask the judge to tell them to wait outside. That's who is going to be in the courtroom. There is also someone called a clerk who is basically like the judge's assistant that has the papers, that gets everybody in and out of the room, etc. Okay. Now, at the start of the hearing, the judge will introduce the proceedings, will tell you that it's your appeal and that they're here today to hear your appeal. They will then look at the documents. They'll look at what your evidence is, what the Home Office's evidence is, make sure that everybody has all the documents, okay? Once that's done, they will then start the hearing. And the first thing that happens is you give your evidence as the appellant, okay? If you've given a witness statement in writing already, there will be a series of questions that you'll be asked to confirm that you want to rely on that statement as your evidence. After you've done that, you will then have a cross-examination from the Home Office's side if they have turned up, okay? And I explained a bit earlier on what cross-examination is. After that, if you've got a representative that thinks that there are problems that have come out of the cross-examination, they can ask you some further questions in order for you to recover from the problems that have arisen in the cross-examination. That's called a re-examination, okay? And then after the re-examination, the judge might ask you some questions as well. That process happens for you and each of your witnesses that you have in court on the day. And then after that, then we have the part where people make their arguments. So the Home Office always go first. They make their arguments for why you should lose your appeal. If they haven't turned up, then there are no arguments on their side. And all the judge has is their refusal letter, okay? And then you make your arguments for why you should win your appeal. If you are unrepresented, the judge might ask you questions so that you know how to formulate your arguments. They won't obviously tell you what arguments to make, but they will guide you through the areas that you need to cover with your arguments. If you have a lawyer, a barrister, or a representative in court on the day, their arguments will be legal arguments. And you heard me covering the areas of asylum law earlier on. The arguments will be related to those things, and particularly credibility. And then at the end of the hearing, the judge will do one of two things, okay? They will either give you the decision there and then, or they will tell you that they're going to reserve their decision and send it to you in writing 2 weeks later, okay? In my experience, the judge gives the decision there and then on the day, once in every 500 appeals, okay? It's very rare. So don't expect them to do that. They will send you their decision in writing afterwards. They always say 2 weeks. In my experience, it could be less than that, or it could be longer than that. But it will normally be several weeks after the appeal. Okay? Good. Working visas for asylum seekers. Are you referring to the Ukraine citizen situation? So you mean permission to work for asylum seekers? Yeah, okay. So the rule on this is that if you've claimed asylum, okay, and you've claimed asylum from the position of having no status in the UK, and your claim has been outstanding for 1 year, then you are allowed to apply for permission to work to the Home Office, okay? And there are certain things that you need to do when you apply for permission to work. You need to show that the job that you're going to do is on the occupation shortage list, okay? And that list is something that's on the government website. I know from my experience of working with asylum seekers from countries like Uganda that a lot of people will work in the care industry, okay? And my understanding is that there are jobs on the occupation shortage list in that industry at the moment. So it depends on your status when you claim asylum, and it depends on how long your claim's been outstanding. But I routinely do permission to work applications for asylum seekers that I act for. Okay?
Does it affect you as an asylum seeker?
No, certainly not. Nothing affects your asylum claim apart from your asylum claim. Okay, so you're allowed to work if you qualify for a work permit whilst your asylum claim is pending, but it doesn't affect the outcome of your asylum claim in any way. Okay.
My name is Abdul from Uganda. The question I have about the work permit. Do they have a limitation of hours we have to work?
No, so the only rule on this is that your claim has been outstanding for a year and that you apply for work in one of the occupation shortage categories. What normally happens, and I'll tell you the process for this, is when you've claimed asylum and you've had your substantive interview, or you're getting to the point where you're going to have your substantive interview, there would be a department in the Home Office that is responsible for your claim, okay? They're called your caseworker or your case owner. So when you get to that point where your claim has been outstanding for a year, we write to your caseworker. We explain your case has been outstanding for a year. We explain that this is the job you want to do. It's in the occupation shortage list. They will then write back and say, on this basis, we give you permission to work. When you do your original claim, you get your ARC, yes, your card confirming that you've claimed asylum, your status as an asylum seeker. When the Home Office gives you permission to work, after we've gone through this process, they will give you a new ARC, which actually says permission to work on it, okay? And then you can work. There are no limitations on the number of hours or anything like that. But if you do a job that's not on the shortage list, that could cause you problems, okay? And so I'd strongly advise against you doing that. Okay? Now, I just want to raise one other thing here. This is important and it's a bit more complicated, so I'm going to explain this to you carefully, okay? When you have your screening interview and you've already got so let's say you've already got a visa and you have your screening interview before your visa expires, okay? At that screening interview, they are going to ask you whether or not you intended to claim asylum when you entered the UK on your visa, okay? If it was your intention to claim asylum when you entered the UK on that visa, they are going to conclude that you entering the UK on that visa was a deception, okay? And if they conclude that it was a deception, then they will cancel the visa that you originally came in on, meaning that that visa never existed. And therefore, you have not extended your existing visa because that visa is gone.
Hello, I just want to know if you were given a court date and then it was adjourned. How long can it take to get another one?
It depends on what the availability is in the courts. So I've had hearings that have been adjourned and the court have told us that we're just going to do a short adjournment and you'll get your new hearing in a couple of weeks, and then we've waited months afterwards. If you've waited a long time after an adjournment for a new hearing and you've got a representative, then they should be following up with the court to find out what's happening. Obviously, the court cannot just fast track a hearing unless there's a good reason for it. So if it doesn't have availability, but you have particular reasons why you need a hearing date, there may be compassionate reasons, it may be that the wait is affecting your mental health or something like that, and you can provide evidence. And that could potentially speed up the process for getting a hearing. But there is no rule that says how long an adjournment has to be for before you get your next hearing. It's about availability, and it's about the issues of your case. So you mean if you've claimed asylum in a date of birth that isn't yours, can you then correct it later? That would be a major, major problem. You need to tell the truth when you're claiming asylum, okay? If you have used a different date of birth to escape your country and you've come to the UK to claim asylum, okay, you should at the first opportunity provide your correct details. The longer you leave it, the more damage it does to you and to your credibility, okay? If you have gone through a whole asylum claim with a false set of details, then you have essentially used deception in a claim for status in the UK. And that can result in you losing your status later. If you are granted indefinite leave to remain, or even if you're granted British citizenship, you could have all of that taken away from you if it was found out that you got it by deception, by giving false details. So my strong advice to anybody is that if they have used a different date of birth or something like that, then they need to own up to it at the earliest opportunity, okay? Remember what I said about credibility and about a rounded assessment. These things are not necessarily fatal to your claim. You have to explain it, you have to own up to it, and if your narrative, your story is strong enough, then it will withstand that problem, okay? But you should always own up to the truth at the earliest opportunity. And if you came in to see me about your asylum claim, I would be taking very detailed instructions from you, and I would expect you to tell me the truth, okay? Because I'm your lawyer. If you don't tell me the truth, I can't do my job properly. And then once you tell me the truth, I will advise you on the best course of action in order to protect your interest and to secure you the result that you want. But getting the result always means telling the truth, okay? You should not lie in an asylum claim at any stage. Okay? Does that make sense?
Yeah.
Okay.